Hi, my name is Goldman, and I'm an attorney with Goldman and Associates. And before I go into one of the many topics for today, I want to say one thing about these videos. More than anything else, these are designed to be informational, and therefore what we try to do is we try to tailor our videos to specific questions that clients or potential clients have asked us. Having said that, if you have a particular question or a particular item for which you would like me to address in video form, let us know. Email us, call the office, and all you have to say is, look, I wonder if Mr. Goldman could talk about this, and let us know what it is, and I'll be glad to consider that and try to answer your question as best we can. Today we have an interesting topic that deals with the relationship between competing parties as it relates to children. The competing parties being the biological parent on one side and a third-party custodian. By third-party custodian, I mean someone who's not a party to the parenting of the child from a biological standpoint. It could be a grandparent, it could be a foster parent, it could be someone else outside the biological union, but whether or not that person had rights above and beyond what the parents have. And I can see situations where, for example, a child will be in an adoptive environment. There'll be a foster parent, and then one of the biological parents comes back into the picture. And the question becomes, what are the level of rights? Well, we're going to talk about a situation where rights have already been terminated and how that works. But let's assume right now we're dealing with some kind of situation where nobody's rights have been terminated. The child just has placement with a non-biological parent. Well, in a situation like that, if the biological parent decides that they want to terminate that relationship, for example, terminate the guardianship and get their child back, they're going to have to show by the appropriate weight of evidence, and the burden's going to be on them, to show that the condition that supported the change in the custodial environment has been lifted. The problem has been solved. The reason for the placement no longer exists, and therefore they want their child back. You should be aware that, generally speaking, whenever there's a motion asking the court to do something, the burden of proof lies with the person filing that motion and requesting that relief. So therefore, if you're going to come and show that, yes, your child was in a guardianship, but that was only because you were having some personal problems, you've resolved those problems, and now the guardianship should be set aside, it's going to be your burden to show the court that it's safe to do that. You're going to have to show the court by the appropriate weight of evidence that the guardianship should be terminated, the child returned back to you. Like I said, it could be a guardianship or some other type of relationship. There's no question that in a situation where the parents still retain rights, that is to say nobody's rights have been actually terminated, in that situation the court will give deference to the parents, because remember, the ultimate goal of these proceedings is a reunification of the child with biological parents. Now, sometimes you can't do that, or sometimes it's not in the best interest of the child that you even try. Those are particular circumstances, and it's going to be a question of whether or not your case meets those circumstances. Having said that, if you have questions about this, give us a call and we'll be glad to help you out. If you just want to find out more about this or any other topic, like I said, just give us a call. We'll do videos that are tailor-made to try and attempt to answer your questions. If you found this helpful, please like, comment, and share.